The mediator is a neutral and impartial professional whose main job is to facilitate the entire mediation process. In order to effectively facilitate mediation sessions, the mediator has to establish and maintain a setting that's centered on the key principles of mediation, which are the needs and interests of the parties, fairness, procedural flexibility, privacy and confidentiality, full disclosure, and self-determination of the parties. The needs and interests of the parties are really at the center of the purpose of mediation, and that's to give the parties the opportunity to openly share their concerns and their ideas for solutions that they can live with. Not necessarily perfect solutions, but solutions that are good enough and that are actually much better than any outcome that they could ever expect from a trial. During and throughout mediation, the mediator explores the needs and interests of the parties by discussing everything the parties want or need to discuss to help them identify and prioritize what the real obstacles are so that they can then get to work on developing solutions that they can agree to. Procedural flexibility in mediation means that there are no rigid processes that limit the parties' possibilities for reaching a solution, which is really what happens in court. In court, the parties are completely limited to what their attorney says or what the judge will permit them to say if they're representing themselves. And more importantly, in court, the parties never really get to tell their story to anyone other than their attorney. So not only do the parties never get to be heard in court, the court process is very highly structured, and that's to comply with judicial procedures, the law, and to protect the rights of all the parties. Mediation, on the other hand, provides all the opportunities for the parties to openly express themselves with very few limitations and tell their stories. Privacy and confidentiality are two of the main benefits of mediation. Unlike going to court, the mediation process ensures the privacy of every mediation session, meaning that the mediation is never open to the public or anyone that isn't a party to the lawsuit. Only the parties, their attorneys, and the mediator are allowed to attend mediation. Now, of course, there are some occasions where one of the parties might bring a supporting person with them, like their spouse in a personal injury case or in cases involving domestic violence. In mediation terms, we refer to these attendees as advocates, and the advocate's participation is strictly limited to supporting the party that they came to support. They don't make any decisions about the agreement, and they should always encourage the party to give mediation their best effort. Mediation is confidential in two distinct and equally important ways. One, private conversations that the mediator has with each party is considered privileged, and it's protected from the other party unless the revealing party gives the mediator permission to share that information with the other party. Second, the entire mediation process is confidential in that nothing that's discussed or discovered during mediation can be used by either party in the event their case ends up going to trial. Lastly, mediation is confidential to the extent that the mediator is completely off limits, meaning that the mediator can never be called to testify about what was said or what happened during mediation. Full disclosure in mediation means that everyone involved must disclose or reveal all previous relationships between the parties, their attorneys, and the mediator that are known, so that any potential conflicts of interest can be addressed prior to the mediation beginning. Full disclosure also means that the parties must be completely honest about everything they share with the mediator, and understanding that dishonesty can invalidate any agreement or partial agreement reached during mediation. Self-determination is really what mediation is all about. Self-determination means that the parties have the right to decide what is in their best interest and that it's protected and it fully applies during mediation. In other words, the mediator will, during the entire process, will work with the parties to see what they're willing to do and what they're not willing to do as it has to do with settling their lawsuit. Nobody, not the mediator, not the party's attorneys, and not the other party, can or will make either party do anything that they don't want to do or decide is in their best interest. Included in the mediator's responsibilities include is assisting the parties in navigating the issues that they have in dispute while working toward a mutually acceptable agreement along the way. Equally important to what the mediator does is what the mediator doesn't do. The mediator doesn't make any decisions about the agreement between the parties. The mediator doesn't give the parties legal advice. That's their attorney's role. The mediator will never make the parties do anything that they don't want to do or accept any agreement that they don't want to accept, nor will the mediator require either of the parties to stay at mediation any longer than they want to or than is productive. So you see, the mediator's role is very unique and unlike any other judicial role. While the mediator has no authority to settle the outcome of a lawsuit, they can offer the parties a private, confidential, and risk-free setting to settle their lawsuit in a fraction of the time that it would take to go to trial and for a fraction of the costs and stress. If this video has been helpful, please let me know, and be sure to click subscribe so that you're notified every time I upload a new video. Thanks.